Chinese firm Zhongxin Fengzhen Industrial Investment Company Limited, which impounded 3 of Nigeria's aircraft in Paris, France, following the order of a French court due to a dispute with Ogun State, has released one of the aircraft, an Airbus A380, recently acquired to replace former Air Force One. But Zhongxin Fengzhen Industrial Investment Company still held the 2 of the country's aircraft. This was as the federal government stated that it was taking steps towards resolving the dispute. Foreign Affairs Minister Yusuf Tuga, who reacted to the matter, attributed the dispute which resulted in the impoundment of the aircraft to the wrong handling of international affairs by some subnational actors. Following an arbitration judgment in favor of the Chinese firm, a Chinese court had on August 12 ruled that the judgment creditor could attach any of Nigeria's assets abroad in payment of the judgment debt. Joining us now on the show to analyze the judgment which favored the Chinese firm is Michael Castro Aôndoakaa. That's Nigeria's former Justice Minister and Attorney General of the Federation. Great to have you again. Let's clarify something. The judgment given in China that was said that the company could attach any of Nigeria's assets anywhere in the world. Is that right? Because some people also argue that they should have just dealt with Ogun State government asset, not Nigerian government assets in the first place.
Well, thank you very much. Ogun State seemed to be part of the country. And when you are dealing with a treaty, it was the federal government that actually entered into that investment treaty. It was done in 2001, signed by the Minister of Industry. And I've seen the contents of the treaty, very strong contents of the treaty. I was very worried whether the Minister of Justice, even that of Ogun State, or Minister of Justice of Nigeria was consulted. The first issue, I look at Article 14 of it, Article 4, which talked about expropriation, which is that's a new development in international arbitration. Expropriation, which means if you enter into agreement and the state takes steps adversely that depreciate your investment, then you can have compensation. I don't know whether they knew what they were signing. That is including even why you have contracted and the state now changes the laws in such a way that they operate detrimental to you. Is there, Article 4, and I was shocked that somebody signed it. That is the beginning of the problems we had. And then you are dealing with an arbitration. The treaty had 3 areas, 2 strong arbitration clauses in paragraph 8 and 9. The best venue we could have got was one of the paragraphs gave a right to court. And these people had attempted to go to court in Nigeria. If we were clever, we would have had a contact claim. Even when they withdrew their action, they wouldn't have resorted to going back to arbitration. But there wasn't a contact claim because you have alleged that they violated some of the terms of the contract. That must have been the basis on which Ogun State terminated. And therefore, when they filed action in the first instance, Ogun State ought to have raised a contact claim. I did not know why they didn't. Because if they have raised a contact claim, even if you withdraw your action, the contact claim being a separate cause of action, it would have remained. And that would have been the live wire of it. But then there was provisions for arbitration. Comes to the arbitration, international arbitrations, especially when they're embodied in a treaty, you have to be careful. I went through if you draft a fluid arbitration treaty, you are creating a time bomb for yourself. I look at the arbitration agreement. The arbitral provisions did not make provision for the seat of arbitration. That is the place of arbitration. And it left it hanging to the arbitrators themselves to decide the seat of arbitration. And they decided the seat of arbitration in London. And normally when the seat of arbitration is in a particular country, the local courts become the courier courts. They become the couriers. And the applicable laws for the operation, for conduct of arbitration becomes the laws of that courier court, even though reference can be made. So if you see there's a foreign investment act of London which specifically exclude state immunity from commercial transaction. That is, I was so shocked that is where I don't know what to say. But if you look at the issue of attachment of presidential planes, that is where completely the foreign firms are wrong. Sovereign immunity operates in two ways. Though before the New York Convention, which Nigeria is a third party, 160 countries have signed, there was absolute immunity, sovereign immunity. But after the convention, which now recognition and the enforcement of arbitral awards in foreign awards, it became an international treaty which Nigeria signed and demonstrated in 2023. And after that, you have the Singapore Convention, which I understand Nigeria has recently signed. They are also incorporated specifically in our laws, Arbitration Act. Now come to the issue of the enforcement. The arbitral proceedings took place, and I am afraid the issue of jurisdiction was not raised. I saw a clause where diplomatic channels have to be used first, which could have availed Nigeria at that time. I don't know whether it was exploited because it would have been, action going to arbitration would have been premature if diplomatic channels were not first employed because it's there in the agreement. That I'm not aware. I don't know whether it was used, but it was not used. It was wrong. But then, Nigeria having participated by nominating an arbitrator because the treaty made provisions for 3 arbitrators. Each party nominates one, and then they nominate the third party who must be outside the contracting party national. If Nigeria nominated an arbitrator and participated in arbitration, then these other issues of not exploiting diplomatic immunity seem to have been waived. These are the issues. But now, sovereign immunity operates in two ways. What the appeal court in U.S. dealt with was the procedural aspect. I'm afraid when people will say, appeal court say, or U.S. say they can attach Nigerian properties everywhere, I don't think that was an extreme position by those who fight to frighten the country. It has to do, recognition of award has to country by country. When you register, the country will evaluate it. And 2 areas the country will look at is did the arbitrators who rendered the final bidder award exceeded their jurisdiction, or was the arbitral award contrary to public policy? Nigeria is now hinging on the issue of public policy. That is it. But of course, issue of sovereign immunity. But now where I have a major quarrel with the Chinese people is that the sovereign immunity, even though after the convention, the New York conventions have been classified into 2. Absolute sovereign immunity, properties that belong to the state which the state uses for operation of state, not for commercial basis, are immune. They are considered sovereign immunity. For instance, military hardwares, presidential planes, because presidential planes are not used for commercial purpose. Presidential planes are used basically for state functions, and those ought to enjoy absolute sovereign immunity, which I am afraid I don't understand the basis in which, especially like money in the treasury, that is central bank, you can attach because it enjoys sovereign immunity. By here, these are presidential planes. You have to lead evidence to show whether the planes seized are for the purpose of commercial transaction. I can't see how a president plane anywhere in the world, including China, can be used for commercial transaction. So I am still thinking Nigeria have a strong case to make to retrieve those presidential planes because they enjoy absolute sovereignty immunity.
All right. Thank you so much, sir. You've raised some critical points in this case, and thank you for that. Number one, where you talked about they didn't raise the issue of jurisdiction. That's an important fact. And, well, in terms of companies or organizations or even sovereigns wanting to approach other courts, like you've cited, because of maybe the belief in their justice system. But again, that could be a case for Nigeria. But I'd like you to please touch on the fact that the point of view from Senator Ibikunle Amosun, who's come out to defend his point, saying that he entered into that agreement based on falsehood. He even admitted that he didn't quite read the terms, or assess the deal adequately before he entered it, hoping that it would be a temporary measure whilst they investigated the agreement that had been signed by the previous administration. He likened it to the P&ID case, which you played a critical role in. And I'd like you to share, does it have merit? Is there any similarity between this particular incident and the P&ID situation, which after going through, court cases, then, became obvious that was a scam, and Nigeria was awarded $20 million, £20 million, which the Chinese company are now saying they want to confiscate as part of their measures to get their compensation or to get that award given to them by the courts. Is there any similarity between this case and the P&ID case?
Well, I don't have enough evidence. P&ID is a debt with me because I was the Attorney General, and I didn't sign the agreement purported to be signed by my subordinate, which that it is an infraction. And then P&ID was an infrastructure concession where it's similar to this one, but there was no treaty. There was no national treaty guaranteeing investment by P&ID contracting party into Nigeria. But here you have a treaty between the government, People's Republic of China and Nigeria, which guaranteed all contracted investors, which is broadly defined, into Nigeria, and gave them even a provision for expropriation, which means you cannot take over the asset. You can't nationalize without compensation. So the things seem to be a little similar. And of course, it doesn't make sense to me, I must be honest, when somebody signs a document and comes, I did not read it. Because document once reduced into writing is bound, you are bound by it. It doesn't make sense. We can make better sense by saying that, look, national assets are threatened, because we also have some cases where minerals, international cases, where mineral resources are considered as national assets. And a free trade zone can be viewed as also a national asset. There could be better arguments than to say I signed an agreement and I did not know about it. Why were you signing an agreement without knowing something about it? What was the basis? And the specific findings here, if you read the judgment of the appeal court in U.S., finding where the people laid evidence that they did investment, made construction, paid taxes, and there were some pieces of evidence that went unchallenged. And you to come back here and start talking that the P&ID is a standard local classical that where corruption, crime is visually established, then you can it vitiate. Public policies say where crime is involved, arbitration cannot hold. But we're not talking of P&ID here. P&ID, where a group of people came to scam and did things in a manner that were contrary to all the laws, and there was no law protecting them. There was no state treaty protecting P&ID to get into criminality in the manner they went. I participated in P&ID. Me, Tayo, and Apan and Tokpe, we were the Nigerian team So I knew everything that went through. And apart from me, I was Attorney General. So you can't just bring something that you did wrong. We have hopes in this case, but not from the approach of saying, I did not know. There's finding here that the people were locked up. The Court of Appeal in the USA, the people were locked up, detained, that they got a text message that they're going to be arrested. They were detained by police. This is using state. This is the issue. You have paragraph 4 of the treaty which say expropriation should not. But you are using state action against these people, which is findings made. I don't know whether we denied it in the proceeding or not. This is the problem. So somebody to woke up and say that I signed something and I did not know is Rufai. I don't think that makes sense. Does it make sense to you?
It doesn't. Rosus.
Yeah. So okay. So based on that, how do you think what's going to happen as far as the judgment is concerned? If it sounds like it's incompetence, right? If it's not corruption, right? Because of what the statements that have been made. So how do you think the case will end? And then 2, 1 plane has been released, 2 are still being held. Was that plane released in good faith? How do you think the case moves forward from here?
Where the Chinese people ought to release our planes, because on the doctrine of sovereign immunity, they have no right to attach presidential planes because they are not for the purpose of commercial transaction. If a state goes into an investment, even in Nigerian law, like the Federal Housing, try to say that they have the only Federal High Court can regulate them when they went into a contractual relationship with somebody. The Supreme Court said, no, you are no longer acting for declaratory actions, but the state now has created a vehicle to do business. So the transaction will go to our ordinary High Court of a state, which has unlimited jurisdiction to deal with contract matters. So here, if the state waives, for instance, in England, particularly where the seat of arbitration was conducted, and I told you the influence of the Korea courts and the laws where the place of arbitration is taking place. They specifically excluded where the state goes into transaction, commercial transaction, the state cannot claim sovereign immunity. It's there. So it's commercial transaction. Our planes are not used for commercial transaction. Presidential planes are not used for commercial transaction. So, and then let's find out. Arbitration recognition is not done in absentia. You must go to that country. You must file notices for recognition, application for recognition and enforcement. So what happened to Nigerian lawyers when they were served these processes for enforcement? What did they do to protect the planes?
Okay.
Because it's clear in there that the sovereign immunity guarantees Nigeria presidential planes because they are not used for commercial transaction. What did our lawyers do before they were seized? Because they must have been served the process.
Okay, so part of also the story, before that happened, that they went to our planes, the sovereign immunity was pushed aside. I think it was when they went to America and New York court to be able to talk about the arbitration because they had filed cases everywhere. And the sovereign immunity thing was pushed aside. And that's why they had access to our planes in the first place. So I want you to talk through that. On what conditions can a sovereign immunity...
the sovereign immunity in the appeal was in relation to the procedure. Because the planes were not the basis for sovereign immunity claim. It's the procedure of recognition and enforcement. Please. Sovereign immunity was not the basis. Because they could not say that the procedure, I'm going to seize planes. They were seeking recognition of the award, which was the procedure. Was the procedure for this award regular, right? Is it contrary to public policy? It is this. And then we raise issue of sovereign immunity. Now, when the court waives this, you come to the specific sovereign immunity of state properties. Properties that are commercial in nature, which the state established for the purpose of commercial transaction, they cannot be immune.
So you're saying
because of the new convention.
So you're saying because our planes are not, the plane is not a commercial property of state. If it was a commercial property of state, they can go after it, like a house asset, for instance.
They could have gone after it. Yes, but this is a plane. Assets that, like military hardwares, you can't go because they are sovereign immunity. You cannot. No state will recognize and award, give you access to seize military planes.
Okay, I also
no
want...
state can say go and seize monies in a central bank. And then presidential planes are not used for commercial transaction. So they could not have formed the basis for waiver of sovereign immunity. These are absolute immunities that cannot be waived. If you look at the immunity at both of US, UK, this, because it is transactions that are leading to commercial transaction of state parties.
Okay, real
but
quickly,
how does a presidential plan become part of a commercial transaction?
Real quickly, I also want to ask you, since you said that by an initial treaty, that any time a state government signs any contract or treaty with a foreign, partner, a company or the likes, definitely it is Nigeria that is also being represented as a sovereign. Isn't it best now for us to ask all the state attorney generals to be able to tell us what is going on?
Rufai, don't get me wrong.
Okay.
Don't get me wrong, Rufai. I am dealing specifically to this case where China signed an investment treaty with Nigeria.
Okay.
And the investment treaty was made to protect all investment into Nigeria and Nigerian investment in China. This was done in 2021. And this is how arbitration is moving. Where you have bilateral commercial treaties, people go out and they sign, they don't know what they're signing. If you go to the treaty went deep to say all Chinese investment and companies here, the state, when we are talking of state in international law, we're not talking of Ogun State, we're talking of state as Nigeria, we guaranteed it. And they also saw all investment on Nigeria in China, China we guaranteed. And it went where a contracting party, an investor, let me finish. An investor comes into Nigeria and is unfairly treated, and the state of Nigeria does not protect it. A right of arbitration under paragraph 8 and 9 will arise.
Okay, so
that is where they went.
If this contract
they
was
did not go on their individual contract with the Ogun State. If
this contract with Ogun State was signed in 2012, and this treaty was signed in 2021, are you saying this treaty takes a retroactive effect?
No, the treaty has been a binding treaty that guarantees investors into Nigeria from China.
From what year was the treaty signed?
That Nigeria president should 2021.
But this deal was signed in 2012.
2001.
Okay, since 2001.
2001. Yes.
Okay. So you are saying because of that...
And it has remained in force. Guarantee China to come in with their people. It was so wide, allowing China, their nationals, their companies to come in and invest, and creating an obligation on the state of Nigeria to protect their investment. But I told you, I saw an article 4, and it talks about expropriation. Expropriation is a new development in arbitration that is coming up. When a state guarantees and have a subsidiary contract with a contracting party in Nigeria, and he's being treated unfairly.
All right. So Mr. Aôndoakaa,
treaty signed between the countries to seek remedy.
Mr. Aôndoakaa, thank you. So what is that? Asked a question, and I think this is on the minds of many Nigerians who are watching and observing this. What the way forward? Part of that can.
Hello, I can hear you.
Okay. Can you hear me now? Can you hear me? Can you hear me now?
Yes.
All right.
Yes.
So can Nigeria, in reciprocity,
I can hear you,
Chinese assets here in Nigeria? Because if they're saying the investigation is still ongoing, Senator Ibukun Lamosun, the governor at the time who had ended the contract, terminated the contract, being insistent that it was fraudulent, they misrepresented the fact. And when it was under the jurisdiction of Nigeria, they lost the cases in 4 courts. And now they've gone ahead to, as you said, even though they don't have a right to seize sovereign assets, have gone ahead. Can we reciprocate in Nigeria by seizing Chinese assets as well?
Okay, you are raising a new dimension that I have not heard. The new dimension you are saying they lost cases in courts. and if they have actually lost cases in court, and that aspect was canvassed at the tribunal, and the tribunal, arbitral tribunal, ignored it, then that could become a very potent issue for us to say, look, enforcement of this contract is contrary to public policy.
Okay.
So
if the people, because there's a provision for them to approach court.
Yes.
There's a provision for them to approach the court also. If they did and they lost and they went back to arbitration, estoppel will not permit them. And if they did not bring that to us, that is a good ground for us to say, look, it is against public policy. Don't recognize this. And we rush to all the jurisdictions where they have filed to have the enforcement recognized and enforced.
Okay. Another great point you made
that would be a happy development if you can make those
Okay, go ahead.
Yes.
Finish up, sir. Just finish up the thought, sir.
That will be a very happy development. I am very pleased. You have made me to feel good.
Okay.
If there's judgments that they actually sought redress in Nigerian courts, because there's a provision that made the contracting party to also seek redress in Nigerian court. If they did and they lost, they cannot go back to arbitration.
And hopefully...
And if they did not disclose this, that is contrary to public policy.
And hopefully it's time for us to even review our treaty signed in 2001 with China. Hopefully it's time to look at that treaty.
I thought not only treaty fine it's time for the President of the Federal Republic of Nigeria to constitute a committee to look at these treaties, these bilateral trade treaties that people go to sign, and look at the merit of them. Because some of them are time-bound. For instance, this particular one, how many Nigerians can go to China and create an investment like a free trade zone?
Thank you so much for that. Thank you so much for that. Thank you so much for your time.
Wide for China and including all Chinese companies to come to Nigeria, and the state has an obligation to make sure that they are treated fairly. We are not saying we cannot treat them fairly, but if they are not treated fairly, then the state of Nigeria is entitled to give them compensation. You see, that is a huge burden. But that narrow issue you say Senator Musu have, if he has, we can fight the arbitration successfully.
Thank you so much. Really appreciate you, Aôndoakaa, for that.